It is August 25th of 2026, and this is the Court Gallery. Today, we are bringing you a wild collection of cases where defendants simply cannot get out of their own way. We kick things off with a man who managed to get his felony reduced, but still wants to fire his public defender over a single missed phone call. Later, things get incredibly petty in family court when a divorced couple battles over a stripped Harley Davidson and a picture of a Scottish cow. And finally, we end with a serious sentencing for a man who used a massage ruse to trap his victim. From stolen copper wire to dangerous high-speed motorcycle chases. All that and more starts right now.
How are you? Morning, Ms. Lacey.
Morning, Your Honor. Always a pleasure.
You're looking awful professional today. Not that you always don't. You got your work cut out for in this one. Carrie Lee Smith, 26G 717-467. Mr. Smith, your name?
Carrie Lee Smith.
Ms. Lacey?
Thank you, Your Honor. Gabriel Lacey, P79685 for Mr. Smith.
Ms. Collins, I hope you will come up here to this microphone over by the jury box. It doesn't look like it, but it is a
little black square.
that is a microphone. Okay. Tell me your name, please. All right. So your client pled guilty or no contest to domestic violence second. The DV third was dismissed. He was referred for a screening. Have you had the opportunity to review that report with him? And are there any material additions, corrections, or deletions?
I have had the opportunity to review the report with my client, and there are no material corrections or deletions.
And anything that you would like to say on his behalf?
I would, Your Honor. Specifically, I'm actually disappointed by the report, Your Honor. When I read the pre-sentencing investigation report, and then I look over my clients that I've had in the past, when I get a client that has like a third OWI but never had professional treatment, and I wonder how they got there, I think this report is one of those. My client, yes, he is taking responsibility for what he did, but he also realizes that he has a problem with alcohol, and it's a big problem. And he even admitted to the probation officer that he would like to do some substance abuse treatment, but yet her recommendation is just a jail sentence. And of course, after reviewing that with my client, you know, he looks at the maximum time for the jail sentence and he weighs his options, and he understands that probation is lengthy, treatment is lengthy, and if he feels like he'll be set up for failure because he doesn't have a job to pay costs and fines. He's been incarcerated for almost 30 days. And so, you know, he wants me to come in front of you and ask and agree with the recommendation and allow him to do the jail sentence. That is what he would like to do now. And he says he'll get treatment on his own after he's done serving.
Wait a minute, you're fading out. He wants to do the jail sentence?
That is correct. After going over the report from the probation officer, that is his position now, that he would like to just rather do the jail sentence and not seek treatment.
Okay. Well, no disrespect, I'm wondering, what does the report have to do with that decision on his part, though? You're saying you're disappointed in the report, but yet he doesn't want to do treatment anyway, so. And this is a third conviction, a DV second, but it's still a third conviction for domestic violence, and this was his mother. And I'm really repulsed by some of the things that he did and said. So I just want to make sure that everybody is on the same page here. Sir, you don't want to do probation, you just want jail.
I would like to do my jail sentence and seek treatment on my own once I'm out of jail so I can go to the proper treatment center. I want treatment. I want to do it of my own volition and be able to get some more information instead of just being thrown into a treatment that may or may not help me. I'm really interested in getting treatment. But I'm also willing to just do my jail sentence. I'm taking responsibility for my actions, and then I will seek help.
Read the first page of the register. All right.
And just so that, because this is a DV second, I think that I gave him a DV one. DV second is up to 1 year, Mr.
I think
Now,
he
she told
understands
me
that.
90
You
days.
understand that, right?
Yeah, no, it's 1 year. I'm sorry, because it's a DV second.
Okay, well, she didn't, she just told me that it was 90 days when I just spoke to her in the
If
breakout.
you want to
room.
go back into a breakout room, that's fine.
Absolutely.
Okay, so I think we might.
So wait a second. So you don't want to do that now? Is that what you're telling me?
I was told that the jail term would be 90 days. And I said, well, I've been
Okay,
here
fine. I
over
don't want to
30
know what your lawyer
already.
told you. That's fine. I'll put you back into a breakout room with her. And you guys can come out. If you change your mind, that's fine. And then we'll start the sentencing over, okay? I'll be
Yes,
right
sir.
with you. Thank you. Now I'm gonna do Smith, and I'm gonna hope, I think that might be it for you, but you can check with my court office. Have a great day. Thanks a lot. Thank you. Carrie Lee Smith, 26G 717-467. Okay, I need Ms. Collins up here again. Ma'am, come on up to the podium, to that microphone and tell me your name.
Nancy Collins.
Mr. Smith, your name?
Smith,
You got to tell me your name again. I didn't pick it up very well.
Harry Lee Smith.
Ms. Lacy,
Gabriel Lacey, Your Honor.
we're going to start over. Have you had a chance to review the screening and assessment? And are there any material additions, corrections, or deletions?
Thank you, Your Honor. At this time, my client would like for me to withdraw. And he would like to obtain a new attorney.
What'd she do wrong? There's been no harm, no foul here. I get tired of everybody asking for new lawyers.
Well, to his position, I did get assigned him while we were out on strike, so he has had other counsel prior. And when I went to see him and spoke with him the last time, I did tell him that I would call him by the next
You
day.
would
and I was
what? You told him what?
I would call him the next day, and I was unable to do that. So that's a fault of mine. And so he feels like the communication has not been very well.
Because she said she would call you and she got busy and didn't. Is that what you're saying, sir?
No, I have not. I've talked to this woman twice. And
Well,
it's
don't-
not.
show some respect. You talked to
I-
this lawyer twice, right?
Yes.
Okay.
I
She
spoke
got
to
it
her
reduced
twice.
from a 5-year felony to a 1-year misdemeanor. On its face, she's not doing too bad. I don't care if you only talked to her once. So far, she hasn't done too bad. 5-year felony, bad, down to a 1-year misdemeanor. I don't know how she's she's been incompetent or incapable or anything else. So you do what you want. If you want
I
a
feel,
lawyer,
I'm sorry, I don't mean to interrupt.
it's okay. I'm used to people interrupting me.
I apologize.
I'll be glad to allow her to withdraw if you want me to fire her. If you want, if she's telling me there's a breakdown in the attorney-client relationship and you believe the same, be glad to reschedule this for sentencing. If that's what you want. I don't want you to feel.
I feel that it's
Hang on.
okay.
You don't have to give me any explanations. If you want me to terminate this attorney-client relationship, I'll be happy to do it. Yes or no?
Yes.
Okay. Attorney Lacey, permitted to withdraw, I guess.
Thank you, Your Honor.
But so far from what I've seen, listen, Ms. Lacey, it went and worked civil work for a year and a half or so, I guess. I've always thought she's a good lawyer, so I hope you get somebody else in the next draw that you like. But I'm gonna allow her to withdraw. Lisa will have to call MIDC, get a new lawyer for her. I don't even know when she's with NDS if we can appoint. Well, I'm gonna let them worry about that. They wanted to do it, let them worry about it. So you just tell them she's with NDS. If they want to appoint NDS, fine. They don't, fine. I'll reschedule the sentencing. It might take some time to do that. Should we adjourn this 2 weeks, Lisa, or 1?
We can do 1 week. I'll do it today.
All right, I'll adjourn the sentence to 1 p.m. 9/1 at 1 p.m., okay? September
Thank you,
1
Your
at
Honor.
1 p.m. and I will see you then. And I don't think I need an order of withdrawal, so that's all good. Thank you. Mr.
Thank you, Your Honor.
Okay, I'm gonna do that right now. Juan Arias Ibarra, 267-20836. Detective, your name?
Detective Claff, Brownstown Township Police Department.
Raise your right hand, please. You solemnly swear affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole truth, so help you God.
Yes, Your Honor.
Okay, go ahead.
On 8/23/26, at approximately 8:38 a.m., Officer Moxie was completing a crime prevention check at 21902 Telegraph Road. That's the Brownstown Sports Center. While sitting on the west side of the building, Officer Moxie heard and observed a bay door opening, and it opened approximately 5 feet from the ground. Officer Moxie observed a subject look out and immediately closed the bay door. Officer Moxie radioed to Brownstown units, advising them what was going on. At that time, the bay door opened again, and the male subject, later identified as defendant Juan Ibarra, exited the bay door with his hands raised above his head. Officer Moxie observed a burgundy Chevy Silverado that was backed into the building with an extension ladder in the bed of the pickup truck. Officer Moxie spoke with the defendant. While speaking with defendant Ibarra, he stated he was in an argument with his girlfriend and was driving around aimlessly until the defendant came across the Brownstown Sports Center as a place to rest his head. Defendant Ibarra stated he only tried to open one door, and that was the northern bay door on the furthest west wall of the building. He stated that the door was unlocked. Defendant Ibarra stated he entered the building at approximately 2 a.m. on 8/23/26. An investigation determined there was copper wire that had been removed in various parts of the building and appeared to be prepped for removal from the property. Evidence inside the suspect's truck and on scene connected defendant Ibarra to the theft. Defendant Ibarra was placed under arrest for burglary. During a building search, officers did not discover any other subjects within the building, but observed numerous rooms and electrical panels that appeared to have been stripped of all copper, including wires and pipes. The damage appeared to be recent, and there were various tools, gloves, and debris throughout the building consistent with stripping wire and cutting pipes. During the vehicle search, there were multiple branded tools that matched brands of tools Officer Roberts and Whited observed inside the building. Officer Whited observed an orange work glove located in the cab of the vehicle, which was an identical match to the glove found inside the building. While Officer Whited and Roberts conducted a building search, Officer Roberts located a 50-gallon trash can full of copper wire that had been stripped from the building along with other heavy gauge wires from the floor within the room. Officer Roberts observed that the building had been obviously stripped of thousands of dollars of copper wire and plumbing throughout. Once the initial search of the building was complete, DPW employee Jackie Haggerty arrived on scene. Officer Roberts inquired with Haggerty if there had been any signs of copper, wire, or pipe being stolen the last time DPW conducted an inspection of the building. She stated that there were no signs of that at that time. Mr. Ibarra's criminal history shows that on 8/25/2003, Third Circuit Court has a felony malicious destruction of police and fire property, found guilty. 6/4/2010, Third Circuit Court, felony larceny, 20,000 or more, pled guilty. 2/28/24, Pasco County, Florida, intimidation with electric threat to kill, felony second degree, guilty, convicted.
On your sworn testimony, I find the crime, B&E, a building with intent to, was committed. There's probable cause to believe the defendant committed the crime. Also that he has the prior conviction giving rise to the fourth offense notice. I'm going to authorize the issuance of the complaint and warrant. You sent this over yesterday. You'd already dated it. I'm changing the date to August 25th, 26th, initialing it on the complaint, signing and dating the complaint and the warrant for the arrest of the defendant. You could bring him out for arraignment. We'll go from there. Thank you. Sir, your name, please?
I just bought second.
Mr. Westmoreland, are you his lawyer?
That's correct, Your Honor. For arraignment purposes, Attorney Corey Westmoreland appearing on behalf of Mr. Ibarra.
All right. How does he wish to proceed for purposes of arraignment?
Your Honor, at this time, we are prepared to waive a formal reading. My client stands mute.
Sir, I'm going to advise you of your rights. You have the right to remain silent. You do not have to say anything. If you say something in or out of court, whether orally or in writing, it can be used against you. You have the right to be represented by your lawyer today. You have the right to be represented by a lawyer at all subsequent court proceedings. If you cannot afford one, you can apply for one, and I'll be happy to appoint you one, or MIDC will, at public expense. You have the right to a probable cause conference within 14 days. At that time, your lawyer will discuss this case with the prosecutor. If it proceeds to a preliminary exam, and you certainly have that right, as to this one charge of B&E, a building with intent, the people have to show that the crime was committed and that you were the one who probably committed the crime. Do you understand that, sir?
Yes, sir.
Probable cause conference is going to be September the 8th at 9. September the 8th at 9. That'll be in front of Judge Husson. Preliminary exam will be September 15th at 11:15. So September 8th at 9, September 15th at 11:15, and that will be in person. I'm going to address bond. I'm going to listen to anything you have to say. Detective Claft, your name again, sir?
Detective Claft, Brownstown Township Police Department.
Mr. Westmoreland, what would you like to say?
Yes, Your Honor. Mr. Ibarra is currently living locally in Trenton. He was gainfully employed working at 21st Century Demolition. He's not currently on probation or parole. And after speaking with him at length this morning, he did assure me he would be appearing at all future court dates, and he understands the importance of doing so. I would just ask that all that be taken into account when assessing a bond.
What are you asking for, Detective?
Your Honor, with his criminal history, we would ask for a cash bond in this case. There is also a case that's pending out of Detroit for felony burglary, recent May 6, 26.
Also, sir, you have 7 warrants for your arrest. 75,000, 10%. You cannot leave the state without the consent of the court.
Sir,
You cannot.
sir.
Hang on. Hang on.
The warrants.
Hang on. Wait,
How do I have a felony burglary?
sir, turn around and look at me, please.
I'm sorry, sir.
And please don't interrupt me again, okay?
Sorry,
You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You must appear in court as directed. No contact with employees of the Brownstown Sports Center. You're not to enter or go near 21902 Telegraph Road in Brownstown. You're not to have any contact with prosecution witnesses. You are not to possess firearms. You are not to possess dangerous weapons. Do you understand
sir.
all of that?
Yes, sir.
Now you have 7 warrants. I'm not changing my mind. 75,000, 10% is your bond. You'll have to post $7,500 to secure your release. I wish you well. September 8th will be your first court. Thank you very much. Good luck. Okay, Mr. Cobb, I'm going to call your case. People against Mark James Martinez, 267-20145. Your name's Mr. Cobb?
Hey, good morning, Your Honor. Michael Cobb, P78658, here with the Office of NDS on behalf of Mr. Mark Martinez.
Mr. Martinez, your name again?
Mark Martinez.
All right, your lawyer wants me to adjourn this for 1 week, the probable cause conference, and the exam would then follow on the 8th. You have the right to a probable cause conference within 14 days of the date of the arraignment. If I adjourn this case, that means the probable cause conference will not take place within 14 days of the date of the arraignment. Do you waive that right?
I'm not really understanding that.
Okay,
So, Mr.
I'll
Mark,
start over.
Mr. Martinez,
You
Yes.
have the right to a probable cause conference within 14 days of the date of the arraignment. If I adjourn this probable cause conference, it's not going to take place within 14 days of the date of the arraignment. Your lawyer wants to prepare further. You wish to waive the right to have the probable cause conference within 14 days of the date of the arraignment, and I'll put it out till the 1st, till next week, and then the exam on the 8th. So do you waive that right?
Can I get out today?
No, listen, no, you're probably not getting out today unless you can post a line. So do you waive that right or not? If you don't, that's fine with me. I don't like adjournments. We can go to the exam next week. I'm fine with it. Whatever you want. Maybe you need to prep these guys a little more. I don't care if they don't want an adjournment, but I don't want to go through this with everybody. Either you want to waive it or you don't want to waive it, sir.
I'm not still not understanding all this.
Your Honor, Your Honor, I spoke with him last night. Why don't we set his exam for the 1st, Your Honor? I'll be there in person on the 1st.
Okay. All right. You sure?
I'm sure, Your Honor.
All right. We're going to simply keep the exam on for September 1 at 1 p.m. September 1 at 1 p.m. will be the exam. Okay, so then we don't have to worry about it, Mr. Martinez.
Your Honor, what bond do you have for Mr. Martinez?
I have 15,000, 10%. So we're going to go with the exam next week at 1 p.m.
Your Honor, could we address bond?
Yeah, you can always address bond. You know that, but I'll tell you this, he's got 5, 6, 7 warrants out for his arrest. And if I hear it, don't be shocked if I raise it. I'm not trying to threaten you. I didn't set this original bond. Be glad to get the prosecutor out here. These guys don't want to show up and then they all of a sudden see God and they tell their lawyers, get me out. Well, they haven't been showing up in court. I mean, what are we supposed to do? Call in the prosecutor, John. I mean, if they don't show up for something like a traffic offense, what makes me think they're going to show up on a possession of meth case? You know what I'm saying?
I do understand, Your Honor. If the court is not inclined to adjust bond, Your Honor, we can waive the argument.
Good enough. Bonds continued, 15,000, 10%. Got to show up, Mr. Martinez. You've got nobody to blame but yourself.
Oh, I understand all that.
Good luck. Thank you. Stewart, Charles, Tyree, Webster, Stewart, 26B7207761 and 7762. Jeez. I'm coming in now, huh? Your appearance? Detective, your name?
Detective Clash, Brownstown Township Police Department.
Raise your right hand. You solemnly swear affirm under penalties. Wait a minute. What are we doing? Whose is this?
These are arraignments. It's a Detective Morrison case.
He never signed it on record.
Oh, okay.
What signature is that on the complaint?
It's going to be Detective Sergeant Morrison's. I believe he's over there at court. Right?
People, it's Charles, Tyree, Webster, Stewart, 26B7207761. Your name?
Detective Sergeant Morrison, Brownstown Township.
Raise your right hand. You solemnly swear affirm under penalties of perjury the testimony you'll give in these proceedings will be the whole true self you got.
Yes, Your Honor. Is this also for Devin Cash Money before, Your Honor?
And what is that? Is that a different guy?
It's on the same warrant. It's 2 different defendants with.
Oh, yeah. Devin Cash Money the fourth. So these are co-defendants.
Yes, Your Honor.
All right. Raise your right hand again. You solemnly swear affirm the testimony you give in these proceedings will be the whole true self you got.
Yes, Your Honor.
Go ahead.
There just needs to be one amendment on the authorized complaint, Your Honor. The location, 18317 Pine West, so in Sibley, it says Wyandotte, Michigan. It's probably auto-populated because that's a Wyandotte zip code. However, this incident did occur in Brownstown, Wayne County at that address.
Let me just make that note before we go on. Okay. You can go ahead and go.
Well, are you ready, Your Honor?
Yep.
Okay. Your Honor, for the purposes of this read on record, the defendant identified as Charles Tyree Webster Davis Stewart Jr. And his co-defendant Devin Cash Money IV. This incident occurred at 18317 Pine West, Brownstown, Wayne County, Michigan, 4193, 2126 at approximately 23:45 hours. The victim is Jamar Leon Anthony Moore. In summary, the victim picked up two acquaintances in the city of Detroit shortly before the time of incident. They arranged for him to drive to a location in Brownstown to attend a house party. Upon arrival at the location, both defendants robbed him at gunpoint and took his vehicle. They communicated that this robbery was out of retaliation for something that the victim had done to another person. On the following day, both defendants were located in Madison Heights. Madison Heights PD attempted to stop the victim's stolen vehicle, and the defendants fled for a distance before crashing. Both defendants were taken into custody. There was a caller for this, Joseph Alina, witness Estrella Mariquin as well involved. The victim vehicle was reported to be a 2014 Chrysler 200 Michigan registration FBC 5528. When the vehicle was recovered, it was discovered to be a 2011 Chrysler 200, but it was established to be the victim's vehicle that was taken on date of incident. Brownstown officers were dispatched to location at the time of call. After the incident, the victim had gone to the caller's home and asked him to call police because he had been robbed. The victim told Officer Lyles the following. The victim provided a description of the defendants and knew one of them by the name of Charles, who's also called CJ. He knew the other subject as Dev, D-E-V. Charles offered victim $50 for a ride to a house party. They arranged for the victim to pick him up, the other defendant, near 3560 Fairview Street in Detroit. Charles put the address of the Hamptons of Brownstown in the victim's phone GPS, and when they arrived at the location, they went to the playground near the office front of the complex. While at the playground, Charles and the other male pointed Glock-style pistols at Moore, the victim, and stated to give them his phone, money, and car keys. One of the males stated this was revenge for filing a police report against the subject named John Butler in Detroit. The males then got into the victim's Chrysler 200 and fled the scene. Stolen from the victim was an iPhone 16e, black in color, the Michigan driver's license for the victim, $60 U.S. currency, and then, of course, the Chrysler 200 that was owned and operated by the victim. On 8/22/26, witness Mara Quinn called Brownstown PD with information about the case. She stated that a subject named Devin with the phone number 313-719-8181 called her and admitted to committing the robbery. She had his identification because the subject left his ID in the vehicle in the past. He was identified as defendant Money at this time. She reported the following. Defendant Money called her and told her that defendant Stewart robbed someone at gunpoint, that he and defendant Stewart robbed someone at gunpoint by the park in the Hamptons and took his vehicle. He sent a photo of the vehicle. Defendant Money possesses a pistol, FN 509 with an extended magazine, and the two defendants have also a fake Draco pistol as well. Witness Merrick stated that defendant Money shares his phone location with her, which showed him at 956 Sprague in Madison Heights, an address she knows because defendant Stewart resides there with his parents. She provided an iCloud ID for defendant Stewart. She used to communicate with him, paid224@gmail.com. Screenshots of the conversation were sent to Sergeant Smith, who observed to be consistent with the victim vehicle that was stolen. Defendants arrested. The victim also told Detective Sergeant Morrison that he knew CJ resided at 956 Sprague in Madison Heights with his mother because he had taken the defendants to that location in the past. At Brownstown PD's request, Madison Heights PD located the victim vehicle parked on the street near the front of the address and saw that a male had been in the vehicle and exited. They agreed to surveil the vehicle and behalf of Brownstown, and in doing so, observed the vehicle drive away from the Sprague address. The victim vehicle began a high-speed pursuit and eventually crashed near I-75 in Davidson. Defendant Stewart, the driver, and defendant Money, the passenger, were taken into custody. Defendant Money was transported to Brownstown PD. Stewart was taken to the hospital before being transported to Brownstown. Both subjects matched description and information provided by both the victim and witness Merrick Wynn. Officer Roberts went to the scene of the vehicle that the vehicle crashed to collect the victim vehicle marks towing. And doing an inventory search prior to impound, he recovered 2 cell phones from the vehicle as well as a firearm, an FN 509 with an extended magazine. The pistol ended up being an airsoft BB gun replica, but the magazine had live ammunition. Black Croc shoes were located in the victim vehicle on the driver floorboard, which is the item of clothing that defendant Stewart was reported to have been wearing when he committed the robbery. When the cell phones were turned over to Detective Sergeant Morrison used forensic software to try and preserve evidence on the phones. Sergeant Morrison was able to unlock a blue iPhone with defendant Stewart's date of birth and preserve the evidence. Sergeant Morrison was unable to unlock the other phone, but saw a message previews on the screen. That message had been received from Hayden24224@gmail.com, the email address provided by witness Merrick Wynn for defendant Stewart. The victim came to the station, provided consent for a forensic software to extract his iPad, which he began using since the cell phone was stolen by the defendants. He stated that he used his iPad in communication with defendant Stewart following the incident as they had been acquaintances. Sergeant Morrison observed that the victim had communicated with Paid224@gmail.com and was calling him CJ, and they were discussing the incident. Defendant Stewart had told him that his vehicle was up in Clarkson with him at an abandoned building, providing an address. The victim also reported to Sergeant Morrison that during the incident, defendant Stewart gave him a stack of cash, which included at least a $20 bill and multiple $1 bills, payment for the ride. When the defendants robbed him at gunpoint at the Hamptons, defendant Stewart was the one who also took this money away from him. Sergeant Morrison interrogated defendant Money under Miranda. He stated that he just went to CJ's house prior to his arrest, but he had been at his residence the day before. For his contact, he provided the same phone number provided to Sergeant Smith by witness Merrick Wynn for defendant Money. He stated that he'd been at his girlfriend's house in Detroit. He never went anywhere else. He stated that earlier in the day at 8/22/26, he went to apply for the Marine Corps Recruiting Center, but it was closed, so he went to defendant Stewart's house on foot. He indicated that defendant Stewart was the one who possessed the vehicle. He did not know anything about how the vehicle was acquired. Detective Claft and Lieutenant Wheeler interrogated defendant Stewart under Miranda at the hospital. He referred to defendant Money as Dev, consistent with what the victim referred to him as. Defendant Stewart stated that defendant Stewart was at the residence the entire night on Sprague, and defendant Money came to the residence in the morning, bringing the vehicle with 2 other subjects around 10 a.m. He stated that he received the victim vehicle from 2 unknown subjects who walked away from the residence after dropping the vehicle off. He admitted that he and defendant Money had driven the victim vehicle after that time, just defendant Money and defendant Stewart, but had returned to the residence. He stated only 2 of them were in the vehicle when they fled police. He indicated that he had been driving. Madison Heights PD turned over property that had been removed from defendant Stewart at the time of his arrest. $41 cash, a $20 bill, and 21 $1 bills, which was consistent with the currency that was reported to have been taken from the victim at time of incident. I believe that's all I have, unless you have any questions for clarification here.
Based on your sworn testimony, I find the crimes of carjacking and robbery armed were committed by each one of the defendants. There's probable cause to believe those crimes were committed by the defendants, Stewart and Cash, and authorize the issuance of the complaint warrant. You already signed it. I'm signing and dating the complaint warrant, and I'm also dating your signature next to your signature. So I'll authorize the issuance, and they can bring those defendants in for arraignment.
Yeah, you're okay if I stand here for the arraignment?
Sure.
Oh, okay.
Stay right here. You want them both, Your Honor?
I do. And you're representing both, right, Mr. Westmoreland?
That's correct, Your Honor.
All right, gentlemen, beginning with you on the right, my right, what is your name, sir, in the black top?
Devin Cash Money before.
And sir, your name on the left?
Charles Stewart.
All right, your appearance, Mr. Westmoreland?
Attorney Corey Westmoreland, appearing on behalf of Mr. Stewart and Mr. Money.
Your appearance, Sergeant?
Detective Sergeant Morrison, Brown South Police.
And your appearance, Detective Claft?
Detective Claft, Brownstown Township Police Department.
All right, so for purposes of arraignment, how do they wish to proceed?
Yes, Your Honor, at this time we are prepared to waive a formal reading. My clients stand mute.
All right, gentlemen, I'm going to advise you of your rights. You have the right to remain silent. You do not have to say anything. If you say something in or out of court, it can be used against you, whether orally or in writing. You have the right to be represented by a lawyer today. You have the right to be represented by a lawyer at all subsequent court proceedings. If you cannot afford one, you should fill out a petition for one. Also, if you choose to submit to questioning with law enforcement officials, you do have the right to be represented by a lawyer at that questioning. Do you understand that, Mr. Money?
Yes, sir.
And do you understand that, Mr. Stewart?
Yes, sir.
You have the right to a probable cause conference within 14 days. At that time, the people have to show, well, your lawyer will discuss the case with the prosecutor. If it proceeds to a preliminary examination as to each one of these counts, in order for you to be bound over to the circuit court, the people have to show that the crime was committed and that you were the one who probably committed the crime. If they prove that, you'll be bound over for further proceedings on that count or counts. If they fail to prove that, then that count would be dismissed. Do you understand that, Mr. Money?
Yes, sir.
Stewart?
Yes, sir.
All right, I'm ready to address bond, but I'll indicate the probable cause conference will be in front of Judge Hessen. September 8th at 9, preliminary exam in front of Judge Hessen, September 15th at 11:15. I'll listen to anything you have to say regarding bond, Mr. Westmoreland.
All right. In regards to Mr. Money, he currently is residing in Detroit. He was working at Toromina's Pizza. He is on probation out of Detroit. He has no other pending matters that we're aware of, and after speaking with him, he did assure me he would be appearing at all future court dates, no history of absconding, and understands the importance of doing so. In regards to Mr. Stewart, he is currently residing in Madison Heights. He is gainfully employed working at McDonald's. He's not on probation or parole, has no other pending matters that he's aware of. And after speaking with him, he did assure me that he would be appearing at all future court dates, understands the importance of doing so. I would just ask that all that be taken into account when assessing a bond on behalf of Mr. Money and Mr. Stewart.
Anything you'd like to say?
Your Honor, yes, obviously both these crimes are, punishable by maximum of life in prison. They do know who the victim is, where he resides, how to contact him. I would recommend $300,000 cash bond for both, as well as no contact with the victim, Jamarly on board. His residence to stay away from the Hamptons.
All right, gentlemen, I'm going to give you your bond conditions first. No contact with Jamarly and Moore. You cannot write, phone, see, text, email, or communicate with him or have anybody else do any of those things for you or on your behalf. You're not to have any contact with prosecution witnesses at all, except through your lawyer. You're not to enter or go near 18317 Pine West in Brownstown. That's the party they went to.
So that was the nearest address, Your Honor. This incident occurred in the playground area on Pine East, north of Sibley. So the Hamptons complex.
All right, where is the defendant or the victim resides in the Hamptons?
No. So that's where they had him drive before they got to him. So they told him, let's go to a house party there, and he agreed. So where the victim resides is 6150 Fraser Street, Detroit, Michigan 48213.
Well, I'm just going to say, unless you tell me I'm wrong, that they're not to go near 18317 Pine West in Brownstown or 6150 Fisher Street in Detroit. So you're not to go near there.
Yes,
either
sir.
one of those residence addresses. You're not to possess firearms. You're not to possess dangerous weapons. You are required to obtain a tether. You're not to be within 2 miles of the victim, his residence, or his place of employment. You're not to be within 2 miles of the victim, his residence, or his place of employment. You're not to be released until fitted with a GPS tether. You're not to be released until fitted with a GPS tether. Also, again, I just want to reiterate, you cannot leave the state without consent. You cannot violate a law. You must appear in court as directed. As to each one of you, I'm ordering $250,000 cash or surety. Preliminary exam will be September 8th at 9, and September 15th will be the exam at 11:15. Anybody have any questions? Mr. Westmoreland, anything?
Not this time, Your Honor.
Gentlemen, any questions?
No, sir.
Mr. Money, any questions?
No, sir.
Mr. Stewart?
No, sir.
Good luck, gentlemen. Thank you. You'll be in front of Judge Hess.
Thank you, Your Honor.
Thank you. People against Bronson, Kimberly Marie Bronson, 17B, 27222822. Ma'am, your name,
Kimberly Bronson.
counsel, your appearance.
Good afternoon, Your Honor. Good afternoon, your staff. My name is Ted Wallace, P 80922, and I represent Ms. Bronson, who stands to my left.
All right, so as I understand it, she's charged with robbery armed, which only carries with it life. And you somehow got this reduced to a 93-day misdemeanor and a 1-year misdemeanor, correct?
Yes, sir.
So she's gonna plead to assault and battery, and she's also going to plead to larceny, 200 or more, but less than 1,000. Probation, they're recommending 1-year probation. Ma'am, do you understand everything that was said here?
Yes, sir.
If you plead to larceny, 200 or more, but less than 1,000, that's punishable by up to 1,000 fines, a year in jail. Costs are all those. If you plead to assault and battery under a state statute, it is punishable by up to 500 fines, 93 days jail. Costs for all of those penalties. Do you understand that?
Yes, sir.
You got to keep your voice up for me.
Yes, sir.
All right, you are presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to a trial by court or jury. At a trial, you have the right to question their witnesses, to bring in your own, to use the subpoena powers of the court to bring in those witnesses, and the testifier remain silent. If you remain silent, that silence would not be held against you. Do you understand that?
Yes.
Nice and loud.
Yeah.
To the charge of assault and battery, how do you plead?
Guilty.
To the charge of larceny, 200 or more, but less than 1,000, how do you plead?
Guilty.
Were you on October the 8th of 17, and I understand I'm giving you credit, but this has a lot to do, I'm sure, with this deal, probably. On October 8th of 17, were you at 19248 Gudith Road in Brownstown?
To the best of my knowledge, yes.
What did you do that makes you guilty of assault and battery?
Your Honor, may I?
Yeah? I hope she doesn't blow this, though.
I understand that. So, Bronson, on that date, the judge just stated, were you soliciting being solicited as for prostitution?
Yes.
And during that, and at the time, the daytime, the complainant, I don't remember the name, Your Honor.
October 8th of 17th, and the victim was a James Robert Laub, Laube.
Did a gentleman come to the house that you were in?
Yes.
And did you receive money for prostitution from him?
Yes.
Did you perform what was negotiated on?
No.
And was he threatened with a bat from another person in the house?
I can't state that for sure because I went in the bathroom and then I heard a lot of yelling.
Do you have any reason to disagree with the fact that he was threatened with a bat and that
No.
and that he and you do know that the money negotiated for prostitution was not the services were not rendered, correct?
Yeah.
You received the money, correct, ma'am?
Yes.
How much money did you receive?
Honestly, I don't
Was it more than $200?
know.
It was negotiated for more than that, Your Honor. I don't think I think that she received some items also that
Did you receive items of value and or cash that exceeded $200 in value? Yes or
Yes.
no? What did you receive?
cigarettes and some cash. It's kind of gray because it's been 9 years, Your Honor, but she received cigarettes and I think some other items
Plus cash.
of cash.
Ma'am, are you listening to me?
Yes.
Did the value of those items exceed $200 to your recollection?
Do you have any reason to believe it wasn't over to her?
No.
So you think that the items in value plus the cash exceeded $200 in value?
Yes.
And were you acting with this other person who allegedly threatened Mr. Lobb with a bat?
She was performing the prostitution part of it and negotiating for money and receiving the money after the person showed up. So
I know, but
likely-
I thought you said, correct me, she went in the bathroom at one point and somebody was allegedly threatening Mr. Lobb with a bat. Did I misunderstand?
Yes, the co-defendant in this matter was that the scheme was to lure people in, and the co-defendant came out with a bad spread. It was the overall scheme.
Is that true?
Yes,
You were acting in concert with Mr. Koppel.
Christopher,
Is that true?
yes,
Are you on probation or parole?
no,
Anybody force you to plead guilty?
no,
I'll accept those pleas. Dismiss the armed robbery. So I'm accepting the plea to larceny, 200 or more, but less. You're satisfied, right? Larceny, 200 or more, but less than 1,000. I'm also accepting the plea to assault and battery. I'm dismissing the RA file. I'm going to give you a sentence date. I'm going to continue the bond. We are going to have a sentencing date, and that will be on what day, Lisa?
September 1st. Do you want to
Yes,
do
was she
1
under
o'clock?
were you under the influence of anything?
was I at that time?
Yeah,
Yeah,
okay, that's fair. I just asking. I'm gonna order a screening and assessment.
my intake has been cleared.
Okay, I'm ordering a screening and assessment right now, and we're gonna notify the victim.
I believe that the victim's here, Your Honor, if that would help.
Where's Mr. Coppola or Mr. Love? Can you come back here, sir, next week at 1?
That would be very convenient for me, Your Honor. I'm starting a new job next week.
I can allow you to get on Zoom, but I don't want to rush this, and I want to report on her.
I'll see what we can do to make accommodations, sir. I'll make, if I can use Zoom.
Yeah, we'll let you, then they'll explain how to do it. September 1 at 1, screening and assessment. And we'll do that here in person, okay? And if you need to appear by Zoom, that's fine, okay?
Thank you, Your Honor.
I'll see you next week, counsel. Thank you.
Thank you.
Angela Marie Socorro. This is 25B1475438 and B and C and 21W828729. Your name, ma'am?
Angelica Sakuro.
Counsel?
Attorney Corey Westmoreland appearing on behalf of Ms. Sakuro.
Good morning. She's got 3 incidents. Let me just double check something here, please. She's got an offense date of December 11 of 24. That is the operating with the presence of drugs out of Brownstown. On that same date, she picked up a possession of a controlled substance out of Brownstown. And on that same date, she also picked up a possession of drug paraphernalia out of Brownstown. So for those cases, does she stand mute and waive formal reading?
That's correct, Your Honor.
Boy, she doesn't get to show up. I think that's pretty clear. Does she work?
Yes, Your Honor. She was working, but she has been in custody since July 28th.
Where does she work?
She's working at Makeover Essentials.
She's also got a case from July 13 of 21, retail fraud. She's getting waive formal reading on that.
That's correct, Your Honor.
Where have you been, ma'am? I'm talking to you. I'd like to know where you've been. I mean, you don't show up in court here.
But yeah, it's hard for me, the whole transportation thing. I'm staying in Detroit.
Well, then I gotta tell you, if you can't come to court because you can't get a ride, then I'm gonna have to get you a ride, right? I don't like this. I don't like this at all. And if I gave you $1 million every time you came here, you'd be here. I don't even need to give you $1 million. I could give you $100 and you'd probably be here, but you don't show up. And that's not good. I don't like it. It's disrespectful. Anybody ever tell you that before?
No.
Well, I'm telling you, I think it is. Anything else you want to say, either one of you, regarding bond?
Your Honor, she is currently residing in Detroit. She was gainfully employed. She's currently on probation out of Romulus, but after speaking with her, she understands the importance of appearing and actually taking care of and clearing up all her matters.
New address. Where do you live, ma'am?
It's 7786 Braille.
Oh, that's in Detroit still, right?
Yep.
Okay, did I misunderstand? I thought you said she was living in Romulus. Did I misunderstand?
No, she's on probation out of Romulus.
I'm sorry, I did misunderstand. Shame on me. How many drunk driving she have?
This is my first one.
Allegedly.
I see some ugly things in here. Ma'am, you've missed multiple court dates on this. On the retail fraud, you're not to have any contact with employees of the Woodhaven Lowe's. You're not to have any contact with prosecution witnesses. You're not to enter 21,000 West Road at the Lowe's there in Woodhaven or any other Lowe's store. On the drunk driving, no alcohol, no marijuana, no illegal drugs. You're to attend AA, NA 3 times a week. You cannot leave the state without the consent of the court. You cannot violate a law. You must appear in court as directed. You missed 5, 6, 7 court dates, 15,000, 10% on the OWI, drug charge and drug paraphernalia, 7,500, 10% on the retail fraud. I will give you the earliest court dates I possibly can. Lisa, we can't do better than the 2nd with Brownstown.
No, Judge Heston's off this week, so they're not here.
September 2nd at 9:45, you'll be in front of me. I do hope you can post, but you cannot do this. I'm sorry. Good luck to you. Wish you well. September 2nd, I'm doing, what about Woodhaven here? What time is that one going to be, Lisa?
We were doing the same day.
Oh, they're both here on the 2nd?
Yeah, they're both here. Yep.
Okay, September 2nd at 9:45. One of these days, I'm going to figure out who's here when. Good luck, ma'am. Thank you.
Thank you, Judge.
Thanks, counsel.
Have a nice day.
Let me look at this. How long is this one going to take?
We will go on the record in the matter 24 FA 78, in re the marriage of Michelle Phelps and Richard Chanel Jr. Appearances are, we do have Mr. Chanel appearing in person without counsel. We do have Ms. Phelps appearing in person with counsel Kathleen Gionis. We're set here today for a contempt hearing. The parties were in front of the court on June 2nd, 2026, which the court did hear and contested divorce and did make final decisions and rulings as it relates to the marriage at that date and time. The court did issue a written decision on June 9th, and shortly thereafter on June 11th did do a findings of fact, conclusions of law and judgment of divorce. However, since the time of the divorce and since the court issued its final order on the property with certain deadlines, plaintiff Ms. Phelps or petitioner Ms. Phelps and through counsel is alleging that Mr. Chanel is in contempt and has done various things. Is that all correct, Ms. Gionis?
It is.
I'm going to have both parties, Ms. Phelps and Mr. Chanel, please stand up, raise your right hand and be sworn in.
Do you affirm that the testimony you're about to provide in this matter should be the truth, the whole truth, and nothing but the truth?
Yes.
You may be seated. All right, Ms. Gionis, you may begin.
I intend to call Michelle Phelps as a witness.
Well, we were only set for a half an hour with this, and unfortunately, this was double booked, not your fault. The court will accept offers of proof.
Okay, all righty. One of the allegations is that the motorcycle, is this called a nanny bike? No.
It's a Harley.
The Harley Shovelhead?
And what I recall from reading the affidavit and the motion was that the motorcycle was essentially stripped.
It was, and I have here exhibit 1 is the before picture, which my client had. And then exhibit 2 is the after picture, how it was delivered to her, essentially stripped. Those particular documents are also attached to the affidavit as A and B. So those are exhibits 1 and 2. Exhibit 3 is an itemized repair and parts estimate that my client personally prepared by researching the cost of parts and labor. And that will show that the total estimated repair and restoration value is $4,801.16. That's on the motorcycle.
When did she receive the motorcycle? When, if she were to be providing testimony, when would she state that she received the motorcycle?
It was after the deadline. The deadline was the 26th. Do you remember the date they returned it?
It was there by July 3rd.
It was there by July 3rd. She signed her affidavit on July 7th, and in that interim, he had returned it in the condition that you see on Exhibit 2. He also had, before the divorce, removed a 75-inch TV, which he was awarded, but he then proceeded to remove the 65-inch television, which was awarded to Ms. Phelps, and that she valued that in her exhibit number 3 at $398. He removed 2 items that were gifts to her from the children. One is a photo of looks like a Scottish cow with horns, and the other is a clock that the children gave. The judgment provided that he was not to remove anything from the home without her consent, and she did not consent to those things being removed. That is Exhibit 3. And then Exhibit 4, and by the way, I have given Mr. Chanel copies of all these exhibits, is a 4-page time list that I ran off yesterday, highlighting the time that was put in on this matter, a detailed description with the rate of $375 an hour, which is the rate that Ms. Phelps has paid all along. And that amount came to $1,255. This does not include today, which I am estimating 2.5 hours, because that includes travel time, for attorney's fees. And so I would submit these documents as offer of proof.
And Ms. Phelps, all that your attorney has stated on the record while looking at the exhibits, that would be your testimony?
Yes.
Was there anything that she misstated?
No.
Thank you. Anything you want to add?
No.
Mr. Chanel, have you received the copies of these exhibits? Yep. Any objection to the court receiving them?
Yeah,
What is your legal objection?
well,
You can provide testimony as to why you may not believe that they are true and accurate, but what is your legal objection?
well,
You're just contesting what,
yeah, it's like,
Amy.
this ain't right.
all right, so the court will receive the exhibits. Anything further you want to add at this time, Ms. Jonas?
Did I cover everything? We are asking for damages in the amounts that I stated for the motorcycle repairs, replacing the television, and we are asking for the return of the photo of the Scottish cow and the clock, which were gifts from Ms. Phelps' children to her. Did I get everything?
Mm-hmm.
And we're,
His children as well?
I don't,
Yes.
okay, I guess they are.
The couple's children.
Okay.
Gave them to mom.
Yes. And then attorney's fees in the amount of $1,255 plus for estimating 2.5 hours today at $375 an hour. I might add that The parties have an offer on the house. Right now, the closing is tentatively set for October 1st. And so there will be funds available if the court awards damages. In addition to what you awarded in your decision, we are hoping to obtain an award of damages and attorney's fees in the form of a court order so that whatever is awarded can also be deducted from Mr. Phelps' share of the sale proceeds of the house.
So it's tentatively going to close on October 1.
Yes,
And what is the accepted offer?
$305,000. And there's a mortgage, right?
Yeah, I think I remember from,
Yeah.
or I can go back to the divorce notes.
Mhm.
Okay, Mr. Chanel, now is your time to tell me anything that you think is incorrect or why you believe that
Okay.
she's wrong.
This motorcycle, this picture was taken way, way long ago. The bike did not run when I got it. When I received that bike is how this picture is. That's how I
When
received
you're
it.
saying this picture and this picture and this picture, you
Right.
need to identify which picture.
This picture was taken a long time ago.
So again, they're marked.
Yep. Exhibit 1. That picture was taken years ago. Okay, I had John from the other guy's bike shop try to fix this bike. It would not go. Those tins and tanks that are on that bike were not for that bike. I bought them for my other bike. Same with the handlebars.
So where are they now?
They are at my house because they were not for that bike. That bike in exhibit 1 is a dyno. And those tanks, the fenders and everything, state Heritage Softail on it. That is not a Softail bike.
That doesn't matter. Were they on there and were they being used?
No, that bike never ran. It did not run. It was literally taken apart in my mom's garage. You know, I was slowly redoing it. I pulled the motor out, redid it all, because when I bought that bike, it was in pieces. I've been slowly redoing it. It never ran. It never ran. We had it fired once and it never ran after that. It was torn down. I gave her the original tanks, tins, handlebars, cables, everything that was with the bike, I gave to her. I gave her her Nani's bike, let's say, not Rick's bike. I gave her Nani's bike.
So were those pieces, the orange pieces on exhibit 1, were they installed on the bike, screwed on the bike? Or how were they placed?
In that picture, yes, they were. But at the time, that was only for a brief moment. That was never intended to be on that bike. It was for my other bike. Because it's not the brand of that bike. That bike shown in exhibit 1 is a dyno. A totally different model from the Heritage Softail, which I wouldn't let fly on any of my bikes, you know, because why would you run something different?
So I'm hearing that it's the same bike, just parts that don't belong on that bike?
Yes.
So when were those parts that you say don't belong on that bike removed?
As soon as I tore it all back down,
When would be,
literally right after this picture,
which would be,
years ago, probably
be an
like
idea.
5 years ago.
You have an idea. June, July, August, 2021.
Well, it'd be during the winter time, so November, December.
Of what year?
We could say back in 18, 19.
2018 or 2019?
Yes. I mean, the bike never ran. I mean, I left it with brand new tires on it that, you know, when that bike was a basket case when I got it. It come in pieces.
But when you got it, did it come in pieces as exhibit 1?
It never even looked like that.
What did it look like when you got
It
it?
had, didn't have the bars. It looked like this,
Which would be,
exhibit 2. I mean, I was trying to get it up and going, you know, and then, yeah, because we were supposed to go through her mother's ashes and her stepfather's ashes, go bury them. But that never happened because we never got it running.
Okay. Now, as to the TV, the clock, and the picture.
Okay, the TV, Michelle was not living there at the time, she'd already moved out, right? So I asked her because, do I get any of the house furnishings, whatnot, she wasn't there, so I figured, all right, well, the clock, yeah, I probably shouldn't have took that. But the picture, she has moved out recently before, and she's left that picture. She never took that picture. So I figured that was mine, so why couldn't I take it?
Well, were you here on the date of divorce when the court
Yeah, I was here.
issued its order?
Yes, but she was moved out already. I said, I'm trying to be civil with her and trying to get along with her, but she won't respond back to me or anything else. And I'm like, Michelle, so I have to go through my kids to, hey, can you ask your mother this or whatnot? And kids are, well, Dad, we don't want to get involved. We just want to get along with both you guys. But my youngest, she has been trying to get with Michelle, Mom, can you at least answer them,
Do you want the picture?
Not now. If she wants it, she can have it. I brought it with, it's sitting in my truck, same with the clock, same with all the stuff that came on this bike is sitting in my truck.
So you didn't return all of the stuff, or are you talking about the orange parts and those things?
I'm not talking about the orange parts because those
What
weren't
parts are in your truck?
the ones that came with the bike. They weren't on it, but they came with it.
Which would be?
The tanks, the fenders, the handlebars, the cables, anything that was with the bike, that we got when we bought it.
Why didn't you provide those parts
I
to
did.
Ms. Chanel?
I did.
Ms. Phelps.
I brought them to the house. And that bike was delivered on the 26th.
All right, Ms. Jonas, do you have questions for Mr. Chanel?
I still have, all right, the TV. Yes, I did grab a TV at the time, but then when we were broken up and I was working in Montana, I did buy some other TVs that should have been mine, but she took them too. It's my 60-inch TVs. So I was like, well, I'll give you your TV back when I get my TVs back. I mean, fair is fair.
We already had the divorce. You only asked for certain things. The court ordered you certain things. All other things went to Ms. Phelps, right?
Well,
that's what it says. That's what I said.
Okay.
And at the time, you're like, I'm done with it. I'm done. I just want to be done.
Well, I do want to be done, and I'm trying to be civil with her. I thought we could get along and everything, and still talk. And I mean, we got a married wedding coming up for our daughter, and we have to be civil and talk. And it's like, why can you not just talk to me? I mean, we could have figured this out without coming to court today. We could have, I don't want to fight with her. I still love her. She's the mother of my children. I don't have a hateful bone for her.
All right, so I'm hearing he'll give back the TV, the clock, the picture.
I'll give it all back to her.
The issue is the motorcycle, and quite honestly, even with the offers of proof, I don't have any identification of what parts. So that one's still kind of out there because I don't think it's been proven by what's been stated.
Okay, she did inform me that photo, you took it, right?
Yeah, it was in 2024.
Did you take it?
This? Well, it wasn't.
Did you take it?
My son had that picture.
Okay, her son took.
All right, yep, so her son took the picture. He's not here to testify. I don't know anything.
Okay.
So with motorcycle.
She's had the picture since 2024 of that particular motorcycle. It did look like that. That's what she was expecting to get back. I guess that's about all we can say. He had to take the affirmative step of taking all of those things off, assuming that the day that we were here for the final divorce, it was in the same condition as is shown in Exhibit 1.
And I believe at the date of divorce, Ms. Phelps did confirm that it was not running. It was not a working motorcycle,
Correct. It may not have been running, but it looked like that.
but it had the orange fenders and tank and those things.
Yes.
All right.
You know, those were just sitting on it at the time because of lack of space of putting it. They were just resting on it.
You told me they were screwed on.
In this picture, they were.
They were. So
But
here's the
then
thing.
I
The
tore
court-
the bike apart because
What
we
I'm
were
going to
redoing.
do right now is I am ordering that the TV be returned, the clock be returned, the picture be returned, and the parts that are in this picture, the orange parts, be given to Miss Chanel. It wasn't running at the time of the date of divorce. Both of you confirmed that. So the court's not going to order $4,800 for him to fix the bike that wasn't even working in the first place. So all of the parts that he has in his car right now that he says are original parts, plus the orange parts that the court can see in Exhibit 1 shall be returned within 1 week. As to attorney's fees and costs, Mr. Chanel, did you attempt to contact
Yes,
Ms. Jonas?
not Miss Jonas. I attempted to contact Michelle, you know, I'm trying to be civil with her and get along and we can work this out, you know, it's like.
She didn't want to talk to you,
I guess not, so,
and you didn't try and contact Ms. Jonas.
no.
And
So
Your
as it
Honor,
relates to the or to the attorney's fees, those are granted.
thank you.
We did come for reasons that he took things that he should not have taken.
And so that's for what's on exhibit number 4 plus today.
Plus today.
All right, thank you.
But as to the motorcycle, that was very iffy at the date of divorce as well. So I don't know what condition it actually was in, when, where, and how. But I do know from this picture at one time, it had the orange parts that were installed and screwed on it, whether or not they were for that bike or not, they were a part of that bike at one time. Therefore, those must be returned as well with the original other parts that are in his truck right now. So you have those parts in your truck right now?
Yep.
So when we're done here, deliver those to Ms. Phelps. And then the TV clock, the picture, and the orange parts for the bike must be delivered
I had
within
the
1
TV and
week.
the clock, not the clock, I had the picture and the clock with me also.
You just bring it to the house.
You want them brought to the house? She would like them brought to the house.
All right, so 1 week to bring everything to the house, okay? You want to go do that right now, but that does include that other 65-inch TV. Okay? Anything else, Ms. Jonas?
No, thank you.
Mr. Chanel? Then we are adjourned. Thank you, Ms. Lodemeyer. We will go on the record in the matter 25 CF 55 26 CM 81 State of Wisconsin versus Colin Daniels. The state appears through District Attorney Kevin Schmidt in person. I do have Nicholas White, Defense Counsel in person, Daniel Chapman, Defense Counsel for the misdemeanor matter by video conferencing with approval of the court. We do have Colin Daniels appearing by video conferencing in custody in Burnett County Jail. We're set today in this matter. The court is set for a status conference in the misdemeanor matter with Daniel Chapman. The court did set a sentencing hearing on revocation for Mr. Daniels' other matters simply because I was aware that you would be here, Mr. White, for your other case. Are we able to proceed with the sentencing after revocation or set it for another date shortly?
Your Honor, I'm prepared to move forward with the sentencing today.
We must do that and take care of the matter briefly, but I have reviewed the packet and I don't believe that this should take very long or it should be very lengthy. And Mr. Schmidt, we do have spillover time for the other hearing. Okay, so Mr. Collins or Daniels, you are appearing by video conferencing. Do you understand you have the right to be here with your attorney, Mr. White, in person?
Yeah.
Are you okay with appearing by video conferencing, or do you want to reschedule this and be in person?
I'm fine with the video conference.
Okay, if at any time you have any questions or concerns and you need to speak with your attorney, let me know and I will have him go into Zoom and I will send you to a confidential breakout session, okay?
All right.
All right. Are we in victims' rights compliance?
Yes.
Okay. The court has reviewed, well, the victim statement for the other matter, Mr. Chapman is representing, but there is not one in this case. All right, so the court has reviewed the packet. Has the state received and reviewed the packet?
I received it. I reviewed it. I have no corrections. I believe the credit is probably agreed at 94 days.
94 days. All right. Mr. White, have you received the packet and reviewed it?
Yes, I have, Your Honor. I don't know any errors or omissions. I would stipulate to 94 days sentence credit. That'd be the time that he's been in custody since this revocation hold, also including 6 days from the original arrest to cash bond being posted. I had a chance to review the packet with Mr. Daniels. We're prepared to move forward today.
All right, Mr. Schmidt, argument and sentencing recommendation, please.
I'm asking the court to follow DOC's recommendation in this case. DOC recommends 9 months. There are 12 months available, making this a 75% sentence. I think the reasons for following this is the violation that triggered the revocation also involved alcohol, which is concerning, especially since the revocation packet indicates he hasn't done AODA. It is to his benefit that he's done prior appointments and skill building, and they had positive input about that. But the lack of AODA on a drinking violation leading to a violation that's also related to drinking, plus one other drinking violation on supervision that didn't result in revocation, shows he had multiple strikes. I think 9 months is reasonable considering the facts of the original 2025 case. It was a serious case that got pled down because of hopes of treating alcohol addiction. That didn't happen, so the court should follow DOC's recommendation. Thank you.
Mr. White.
Thanks, Your Honor. We're recommending that you consider a 6-month jail sentence here. Just a few notes on the prosecutor's comments here. I believe looking at the plea questionnaire waiver of rights, misdemeanor failure to stop, it states that the maximum penalty upon conviction would be 9 months or $10,000 fine. My understanding here from review of that document and then some of the statutes is that this is actually a 9-month maximum sentence. That was just my understanding. Maybe wrong, maybe looking at the wrong thing. But with that in mind, it appears that DOC and the state is asking for the maximum sentence, which I think we all understand is somewhat rare. The maximum sentence in a case is used for the most severe situations, the worst of that particular crime that could be possible. Your Honor, I don't think that this is the most egregious type of fleeing that occurred. Just reviewing the criminal complaint. Let's see.
And I'm just going to, before you continue to argue,
Yeah.
Mr. Schmidt, in my review of Wisconsin statute 346.04 paren 2T, I'm finding the maximum possible penalty is 9 months of incarceration and a $10,000 fine limit.
Yeah, I misspoke. I saw the unclassified misdemeanor and I forgot it has the penalty of a Class A misdemeanor, even though it's unclassified.
Okay, does that change your argument or recommendation to the court? Because you were arguing it's a 75% sentence versus what the max would be, therefore follow DOC.
It doesn't. I consider the violation more serious than the underlying offense.
Okay, sorry, Mr. White, you may continue.
Thanks, Judge. I was just looking for the notes that I had on the incident. I didn't represent Mr. Daniels on that, but reviewing it, looks like it was a motorcycle chase. He was speeding around midnight. The officer had lights and a siren on. The defendant must have noticed that. He did not stop. nearly crashed his motorcycle on a Gandhi Dancer trail. That put himself in danger and harm's way. Anybody else that was there could have been endangered as well. I see that this started off as a serious, very serious case by being a felony, was negotiated down to a misdemeanor. I think part of that is just that they eventually found Mr. Daniels. He admitted to drinking. He eventually complied and admitted to the evasion. He knew he was on probation. He shouldn't have been drinking. Hearing the prosecutor's comments, I also note that this seems to have happened before, more like a deja vu where Mr. Daniels has been on supervision. He was told not to drink. And unfortunately, he relapsed. He went out to drink. And when he was drinking, he made some very bad decisions. Now there's a new pending case. Not the same type of facts, but similar type of situation. Mr. Daniels on supervision, drinking, made some bad decisions, and definitely scared some people in the new incident. Looking at the way the misdemeanor case was resolved, he did have a traffic ticket. The rest of it was dismissed, and then the felony reduced to a misdemeanor. With that all being said, I think that it's fair to go below the maximum possible sentence here. We'd ask you to consider 6 months. My client has some goals upon release. He's got a home and a truck that's waiting for him. That tells me that he has stable residency. He's got a way to make it to work. He's got a way to make it to probation or wherever else he needs to go. I believe that he has supervision remaining, even though this was revoked. I believe he has a different case that he's still under supervision with. So he's still going to have to follow through with whatever's ordered there with treatment, sobriety, and the like. Looking at his school options, he may have to go back for something better to give him some more job options in the future. He lost his job while being incarcerated, but he's able to work for himself. He may be looking at getting a union job. And I think that all goes towards his character and his stability. I think his intent is to remain in a relationship with Jada. She's referenced in the revocation packet. I believe she's a victim in the new case, but there would be some need there for some counseling. Some personal things need to change between these people, and Mr. Daniels needs to make some changes. He understands that. So I know that he's been busy while he's been in custody. He's been doing some courses in the jail. He's been going to the church there. I don't think he did that before being in custody. And just brings me to my point that while he's been in custody, he started off strong doing workbooks on addiction, meeting with a pastor, Sunday and Tuesday church and Bible studies. Your Honor, I'd argue that at the beginning, when someone's in custody, it's when the punishment is most effective to them. But at some point, being in custody is no longer providing the right kind of punishment. It's just kind of dragging a person down and hurting their ability to recover afterwards and be a more productive citizen. So I'd ask you to consider the 6 months here. Thank you.
Thank you. Mr. Daniels, do you care to make a statement here today? You do not have to, but it's your only time to let me know anything you would like me to know.
I kind of just wrote something up here before I'd like to say something.
If you're going to read something, please read it slowly and enunciate your words and make sure that you speak pretty loudly so that my court reporter can take everything down.
Okay. I'd like to apologize for taking up time in court, and I'd also like to apologize to Jada. Since I've been in custody, she's been taking care of our daughter alone. And my aunt, she's been taking care of my dog. Being in jail, I've learned that I'm powerless under the influence of alcohol by attending AA, along with help from my pastor, Jeff, who's been working through the crossroads away from addiction 10 steps with me every Monday. He's shown me that I have a lot of positive support and better ways of dealing with issues and negative emotions by helping me know God and turn from alcohol or other distractions that I relied on to mask hard feelings. He's helped influence me on making a plan to a better life with more structure and positive decisions. I plan to keep seeing him and get an AA sponsor and attend more meetings when I get out, along with looking into couples counseling with Jada to strengthen our relationship, learn to communicate with each other better. This slip up has jeopardized a lot in my life. I lost a great job and let loved ones down. My daughter, my puppy, and Jada the most. I just want to get back on track and focus on a better life. Not a bad person, I just messed up the progress I was making. My time has been very helpful here in many ways, but the biggest one is that I don't ever want to come back to jail, and I'll do whatever it takes from happening again. Thanks for letting me speak.
Thank you, Mr. Daniels. The court has received and reviewed the revocation order and warrant, and quite honestly, I do remember the facts of this case very clearly, and they were stated in a good summary by Mr. White on the record. This was serious because it involved alcohol, and it involved you riding on a motorcycle at excessive speeds and trying to flee and elude an officer. You could have been injured, you could have been hurt, and God forbid you could have injured or hurt someone else. But thankfully, none of that occurred. You don't have an extensive criminal history. I'm not aware, and I'm not saying that Mr. White is incorrect. It could be Minnesota. I don't have full access to Minnesota, but I'm not aware that you will be continued to be on probation after this, Mr. Schmidt.
He's on supervision for the same OWI that out of Minnesota that he was on the 2025 case. He still is.
Okay, so you're still on that supervision. Okay, so you will still be on supervision. And you still have the ability to complete the necessary requirements on supervision, including that AODA assessment and more skill building or cognitive thinking type of programs, which that is a positive here. Your statement sounds like you have had a lot of self-reflection and that you are taking this seriously, and that when you are released, whenever that may be, that you will then move forward in a positive way because you understand the significant and serious impact that your actions have upon your family, especially upon your young child who has now had to be away from you for a very lengthy amount of time. I don't think that this is a maximum possible penalty case, again, because you don't have a significant criminal history. This was serious, but I don't think that the community is going to be harmed or at risk if you have a lesser sentence than the maximum penalty, because again, you're going to be on supervision and you do have this other case that Mr. Chapman is representing you on. I don't know where that's going or where we are with that at the moment. But because of the facts stated on the record and the fact that you can continue to improve yourself and go to church and do the AODA and do the cognitive thinking classes, the court is going to follow the recommendation of the defense here, and I'm going to sentence you to 6 months of incarceration with 94 days of jail credit. You will get good time. So you do have some time to continue to sit and to think about this, because hopefully this is going to be something that will not happen again. I like your way of thinking and the courses and the therapies and the plan that you are working out. So please put that into fruition. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I believe that is all that we have to cover. Any fines and fees will be converted to a civil judgment. You're still going to owe them, and if you fail to pay them, the court could issue a warrant and you could sit up to 6 months in jail. Mr. Chapman, what are we doing with the other matter? Are we setting it for a status? Are we setting it for a plea and sentencing? I know that there was a plea offer, but it entailed Mr. Daniels being released from custody and having time to complete certain things. My guess is an AODA assessment and whatnot.
I'm thinking that given the sentence today, we should set it for a status conference approximately 2 months out. By then, I will expect Mr. Daniels will come back with at least his AODA scheduled. The plea agreements that we're hoping for in my case will involve him doing that up front.
So you're looking for a date and time when he can be out of custody? What about?
Out of custody and schedule the assessment.
Would October 8th be too soon?
No, I would not say so. It might be something he can do from the jail too. We will work on it.
All right, October 8th, 9 o'clock. Does that work, Mr. Chapman?
It doesn't actually. I'm in St. Croix at 9:30.
Oh, you are coming back October 5th at 9, but
yes.
Let's do October 5th at 9, and then we will just get an update on where Mr. Daniels is and what we need to do, and if we're setting it for something else after that.
Thank you.
All right, thank you. We are adjourned.
Your Honor, on the sentencing case,
yes,
it's something I've been informed from Mr. Daniels' parents that there's a death in the family. There's a funeral set up with visitation at a funeral home and graveside service. I got a message that that's set up for September 3rd on a Thursday. I just wanted to let Your Honor know that ahead of time. This might be a situation where we'd be asking for a furlough just for that day.
thank you for the notification. Please put it in writing. Let me know who has passed and the relation. And again, those specific dates and times.
Okay, will do.
All right, thank you. Anything else?
No, that was it.
All right, thank you. We are adjourned.
All right, good morning. We're back on the record in the 53rd Circuit Court for the County of Sheboygan, and we are providing public access both in the courtroom and also online. And the next case that we have on this morning's docket is People v. Devin O'Rourke for sentencing. It's filed 26-7164FH. Counsel, you want to state your appearances, please?
Melissa Goodrich, Sheboygan County Prosecutor.
And Matthew Samuels on behalf of the defendant, Devin O'Rourke. He is present and sitting to my right.
Okay, and court staff advised me, and I just want to remind counsel then, the victim in this case is a minor, so let's all take care not to use the victim's name. And as we are live streaming the proceeding, in that, Ms. Goodrich, do you anticipate the minor victim giving an impact statement this morning?
I am, so I'd be asked
Okay.
to take off live stream at that time.
Okay, and you have no objection to live streaming the hearing, but we can just not live stream that impact statement?
Correct.
Okay, any objection to
I
that
have no
process?
objection to that.
All right, so Mr. Samuels, the sentencing is for attempted criminal sexual conduct in the second degree with a 5-year statutory maximum. The advisory guidelines were scored by the department at 0 to 11 months. Criminal sexual conduct in the 4th degree, a 2-year maximum. Advisory guidelines were scored by the Department of Corrections at 0 to 17 months. And indecent exposure, a 1-year maximum, for which there are no advisory sentencing guidelines. Have you had a chance to review those guidelines and the pre-sentence report with your client?
I have, Your Honor.
Do you have any additions, corrections, or modifications to request to the information in the pre-sentence report?
I do not, Your Honor.
Do you have any scoring challenges to the guidelines?
I will defer the scoring changes to the people at this time.
Okay, and Ms. Goodrich, do you have any additions, corrections, or scoring challenges?
Yes, Your Honor, as to OP 10 and asking that it be scored 15 instead of 10 for predatory conduct, I believe that the avenues that he used to commit the sexual assaults by pretending to engage in massages indicates the predatory conduct in using his position in household.
Okay, Mr. Samuels, your response to that?
Yeah, I don't agree with that, Your Honor. While it does say that there was predatory conduct, I do believe it should be scored a 10 as it was a vulnerable victim, but it doesn't seem anything from the facts that anything is pre-planned as the definition from MCL 777.40 that there was nothing pre-planned lead to the predatory conduct It seemed like it was just kind of a crime of opportunity rather than a pre-planned notion to exploit this victim. So I would disagree with that. I would ask to be scored at 10.
Okay, let me want to review the written impact statement again briefly here. All right, well, the sentencing guidelines for offense variable 10, it's presently scored at 10 points for exploiting victims, either youth or domestic relationship, or I suppose abusing his authority status would also apply here. The prosecutor wants it to be scored at 15 points instead for predatory conduct being involved. That's defined by statute as pre-offense conduct directed at a victim for the primary purpose of victimization. It doesn't require any kind of, extensive pre-planning or anything, but something that occurs before the criminal offense that is designed to, that is primarily for the purpose of victimization. And there's a lot of case law about sort of grooming constituting predatory conduct. This doesn't quite fit the classic grooming scenarios. However, this offender did engage in a ruse with the young victim that he was going to massage her back, and that would be otherwise innocent or non-criminal conduct. And then he's using that ruse to put the victim in a position where he is able to victimize her. So I think under those facts, that would, by a preponderance of the evidence, constitute predatory conduct. So I would grant that objection and score OB 10 in both count 1 and count 2, or I don't know if it counts, the attempt CSC 2 and the CSC 4, I would score that at 15 points rather than 10. Ms. Goodrich, did you have any other scoring challenges?
Your Honor, I'd object to OB 13 being 0 points. I believe it should be 25 for 3 or more crimes against a person, whether charged or uncharged, based on the defendant's own admission that he had touched the minor's breasts 4 to 10 times, not by mistake.
Okay, Mr. Samuels, your position about that?
Your Honor, I'll go directly to the complaint on this. As far as my objection goes, that there was only 1 felony charged, and this is specifically for felonious offenses. With that said, Your Honor, I do believe it should still be scored at 0. Just based on the fact that there was not a lot of felonious, there's no clear fact stating that there was multiple felonious offenses committed to score this at 25.
Thank you. OB 13 is scored for a continuing pattern of criminal behavior, and the prosecutor wants it to be scored at 25 points because the offense was part of a pattern of felonious criminal activity involving 3 or more crimes against a person. That requires the sentencing offense to be a crime against a person, and then it requires it also to be a pattern where there were other crimes against a person committed by the same offender within a 5-year, and that's got to be within a 5-year window of time. And here, and the case law is clear that that does not require the other felonious, well, even the statute says in scoring OB 13, all crimes within a 5-year period, including the sentencing offense, must be counted without regard to whether the offense resulted in a conviction. And I believe that also means without regard to whether the offenses have ever been charged or included in a complaint or felony information charging document. And here the offender did confess to police that he engaged in this several times. He also admitted to other felonious conduct of surveilling the minor while she's changing in the bathroom and in her bedroom while outside her window 2 to 3 times. I think there's an abundance of crimes against a person and against the same victim that this defendant confessed to the police. So by a preponderance of the evidence, there would certainly be 3 or more crimes against a person within a 5-year window. So I would score OB 13 in both the attempt CSC 2 and in the CSC 4 at 25 points. Should you have any other scoring challenges?
No other scoring challenges.
Okay, Mr. Samuels, you have deferred. Do you have any scoring challenges from the defense?
I do not, Your Honor.
Okay, so Ms. Goodrich, with those, let's see, with those additional points, that looks like that'd be 30 additional points. So it would be a total OB points at 50. And let's see, attempt CSC 4 is on the class G grid, and that would place it at offense level 3. Okay, so G only goes till 3, so it still is offense level 3. And I'm sorry, I was looking at CSC 4. On the CSC 4 class G, offense level 3 at 16 or more points is the greatest level. So the points are at 50, the OB level is still at 3, and the range is at still 0 to 17 on the CSC 4. Is that correct, Ms. Goodrich?
That is correct.
Mr. Samuels?
That is correct, Your Honor.
All right, on the attempt CSC 2nd, that is class E, and 50 points brings that to offense level 5. And then with prior record variable C, that brings us to a range of 7 to 23 months. Is that the math that you have, Ms. Goodrich?
Yes.
Mr. Samuel, is that correct?
It is, Your Honor.
Okay. All right. All right, thank you. Mr. Samuels, I did have a chance to review, and Ms. Goodrich, I'll tell you, I have received a written victim impact statement that I was able to review. I also received 2 letters of support for Mr. O'Rourke that I was able to review. And I did receive and review the psychological evaluation and psychosexual risk assessment, as well as the information in the pre-sentence report, including the COMPASS assessment. So Mr. Samuels, with that, any allocution you wish to make on behalf of your client, go ahead.
Thank you, Your Honor. Your Honor, even with the changing of the guidelines, I still think the recommendation is within the scoring of the guidelines. I do think it's appropriate. As this court is aware, there are the snow factors that take into account how Mr. O'Rourke should be sentenced at this time. I will say that based on the evaluation that was turned into this court, rehabilitation seems to be the snow factor that this court should take into account the most. Now, I'm not downplaying what he did, but what I will say is since I've taken over this case, I believe back in March, and all my interactions with Mr. O'Rourke, including the interactions by police, he's done nothing but take accountability for this. He understands what he did was wrong. He understands that this isn't the way that we behave in this society. With that said, Your Honor, if looking through the PSI, and what I think I found most alarming was that, and I'm sure this is a regular kind of thing here, this has happened to him before. I think it shows to the nature and his character that he does have quite a bit of support here. He's got family and he had statements supporting him. I've been in contact with the family, so that's a showing that rehabilitation could be appropriate. I do think the 5 years probation is appropriate. He did serve this country. He's, and again, I think we've all learned throughout the years of being in this business that you do what you know. And this is how Mr. O'Rourke was treated. And again, I want to make it clear, I'm not downplaying what he did. Mr. O'Rourke's not downplaying what he did. This is an egregious thing. However, I still think that there are motives in place and things in place to make sure that he gets this rehabilitation. And I think the rehabilitation is appropriate. The risk assessment shows that that there is a strong possibility for rehabilitation. With these guidelines hanging over his head, if he does not complete probation, it is prison. So I'm asking that you give him a chance to be rehabilitated, do the 5 years probation, which I really do believe is appropriate, based on the nature of this, based on the assessments, based on the fact that he is a clear candidate to be rehabilitated, considering he has served the country, and we all know that that creates a different kind of need. He is setting himself up to work with the VA to sort of work through these issues. Unfortunately, you know, we are here because he hasn't dealt with these issues before. And a lot of them aren't self-inflicted. A lot of times I'm up here arguing it was drugs, it was alcohol. There's no major history of drugs and alcohol abuse through Mr. O'Rourke. This is a product of the environment. And he did what he knew that was done to him and what he knew. So with that said, Your Honor, I do think that the recommendation is appropriate. It is within the guidelines. So I ask that you follow the recommendation at this time.
Okay, thank you, Mr. Samuels. Mr. O'Rourke, you don't have to make a statement today, but you are welcome to. If you choose not to make a statement, I don't hold that against you at all, but you're welcome to make any statement to me that you wish at this time. Is there anything you want to say? Go ahead and stand.
I just want to say that I know what I did was wrong, and I just want to help out in any way I can, people that were affected, and I want to get help. I completely regret everything that I've done.
Okay, thank you, sir. Ms. Goodrich.
At this time, I'd ask to go live stream.
Okay. All right, Ms. Goodrich, any recommendations from the people?
Yes, Your Honor. We are here because between the years of 2023 to 2025, defendant sexually assaulted a family member who was 9 to 12 years of age. The defendant admitted to touching her breast at least 4 to 10 times, exposed himself more than once, pressed his penis into her buttocks under the disguise of massage. He also admitted to videotaping her changing, one time in the bathroom, one time in the bedroom. She caught him once having the phone videoing in the bathroom and hurried up and deleted that video. He's 34 years old. He has no prior criminal history, which is not unusual in these cases. He was employed until his incarceration. He has a high school diploma. The PSI is recommending 5 years probation and 1 year jail. I am requesting top of the guidelines due to his predatory and repeated nature of assaults. I believe that OB 13 covers up to 3 crimes against a person. But by his very own admissions, it was 3 times that 3. I'm not asking to exceed guidelines because he was quick to take accountability in this action. The victim did not have to testify, and he admitted to all of his wrongdoings, but I would ask for top of the guideline sentencing at this time. Thank you.
Thank you. Mr. O'Rourke, would you please stand for the court sentence? Mr. O'Rourke, you're 34 years of age. You have no prior criminal history. You do have some armed forces service. You did, I reviewed the risk assessments, and you did take responsibility to the police when they contacted you. Those are, those are good indications. But there's a lot of aggravating factors here, as the prosecutors outlined and as your victim has outlined. And, I hope you're listening very carefully that, it's not just the harm of the offenses themselves, but then it's all sorts of downstream harms that you work into many people's lives when you act so selfishly. And, when young children are, preyed upon sexually and selfishly by people in their lives, by anybody, but especially by people in their lives that they ought to trust, that causes a lot of long-term harm. I mean, you know that because as your attorney outlined and in the pre-sentence report, you yourself suffered some similar abuse. And, it's just, terribly tragic situation. And now you've done that to somebody else. And the other aggravating factors here are that this involved multiple sexual assaults over an extended period of time. And as the prosecutor outlined, offense variable 13 scored at 25 points for 3 crimes against a person. And here you've admitted to, 10 or more crimes against this person over that 5-year period. So I think there would certainly be, in my mind, certainly reasons to exceed these guidelines. The guidelines for the sentence top out at 23 months in prison. And if I ask myself, well, how much time in prison does Mr. O'Rourke deserve? It's a heck of a lot more than 23 months. I sentence people to prison for drugs for more than 23 months, and you deserve prison a heck of a lot more than they do. There are some limitations in front of me by the statutory maximums of the crimes that you pled to. And there's although the guidelines are advisory, I am required to take them into account. And the prosecuting attorney has outlined that some of those mitigating factors that I outlined for you, those are not reasons to go below the top end. Those are reasons not to go above those guidelines. And so for that reason, I will stay within those guidelines. But the top end of those guidelines is certainly a proportionate sentence to what you have done. So Mr. O'Rourke, there are some financial assessments. There's $186 in state costs, $130 in a crime victims assessment, $350 in court costs. You have to comply with DNA testing. There's a $60 fee for that. You have to be subject to the Michigan Sex Offender Registration Act requirements. And I note that registration has been completed through the Department of Corrections. And on the charge of criminal sexual conduct in the second degree attempt, I'm going to commit you to the Michigan Department of Corrections for a term of not less than 23 months, nor more than 5 years, with credit for 159 days previously served. If it had been the completed offense, I think lifetime electronic monitoring would have been required, but I don't think that's applicable when the statute is actually the general attempt statute. So I will not indicate that lifetime electronic monitoring is required. And on the charge of criminal sexual conduct in the fourth degree, I will commit you to the Michigan Department of Corrections for a term of not less than 13 months, nor more than 2 years, with credit for 159 days previously served. And the misdemeanor of indecent exposure, I'll order that you serve 159 days jail with credit for 159 days previously served. And those sentences will run concurrent with each other by law. Mr. O'Rourke, if you wish to appeal, you can file an application for leave to appeal. If you want a lawyer appointed for you and you qualify, I would grant that, but you'd have to make that request within 6 months of today's date. So we're going to hand you 2 pieces of paper about those appeal rights. It's the same document. One of them is for you to initial for us, so we have a record that we gave it to you. And the other copy is for you to fill out if you want to take an appeal. Do you have any questions for me, Mr. O'Rourke?
Yes, sir.
Okay, good luck to you. Thank you, Mr. Samuels.
Thank you, Your Honor.
What are you supposed to say to something like that? I got nothing. I mean, we sit here day after day and we see all types of people get charged with all types of stuff and serving prison time for all types of things that are nowhere close to that kind of crime. And they serve far more than 5 years in prison. I just don't even know what to say. I do know that I should start the credit and say a very hearty thank you to Scott McIntosh, who came in 21 minutes late and gave a wonderful, very kind super chat. And I do thank him very much for all of the lively chat and chat tonight, Scott. Thank you very much for being here tonight. Vegas Starlight, happy Tuesday to you too. And Kiernos, great to see you. Let this be a lesson. Screen your lot lizard. Oh, don't screen the lot lizard. Here's the best screen for a lot lizard. Avoid the lot lizard. That is the best screen for the lot lizard. Okay? So, if you're wondering what the best screen for a lot lizard is, it's just avoid the lot lizard. In total. Completely. Just don't do it. That's all there is. Just like if you want to make sure that you're never going to be disappointed by your kids, there's an absolute solution to that. Never have kids. Those never disappoint. See, look at that. Look at how cute that is. That never disappoints. See? Fur babies are better. Lot lizards are bad. Kids are trouble. Fur babies are where it's at. The wolf has spoken. That is your wisdom for the day. Ladies and gentlemen, thank you for hanging out with me. It has been an interesting set of cases tonight. We had a whole lot of stuff with Judge Dad. Judge Dad got big mad today. And we'll have more from Judge Dad. I have good feedback. There's more to come. And then with Judge Mogen, we got the guy who was taking the Harley apart. That's the first time I heard about something like that. We've heard a lot in divorce cases, but contempt for stripping a Harley and taking a picture of a Scottish cow, man, that's a new one. Then you got the guy who stripped everything. Stripped all the copper from everything, everywhere, all over the place. Uh-oh. The puppy's after the kitty. That's the kitty over there. Ladies and gentlemen, I am your Lone Wolf Fizzle. I am your host for these little get-togethers. I'm your curator for this little archive of court goodness. And I am done for the evening. Thank you very much for hanging out with me. I will see you next time. I am out. And remember, only you can take a bite out of crime. Bye! Hmm.